Good morning, viewers. Welcome to Consumer Shorthand classes. Get ready. 5 seconds. Start. There are two suits, one filed by the plaintiff and the other filed by the defendant against the plaintiff. If the plaintiff does not appear and he withdraws his suit, or the suit is dismissed for default, the claim of the defendant does not get affected for set off, and the decree is passed in favor of the defendant by the court if he proved his claim. The defendant can specifically deny the allegations made in the plaint against him by the plaintiff. Besides this, he can claim to set off any sums of money payable by the plaintiff to him as a counter defense. Further, if he has any claim against the plaintiff relating to the matter in the issue raised in the plaint, the defendant can separately file a counter claim along with his written statement. Thereafter, the plaintiff can also file a replication or his written statement in his defense to the counter claim of the defendant. This is stated in Order 8, Rule 6A, Subrule 3. Written statement is the response given by the defendant bar respondent in a civil suit. Format of a written statement is governed by Order 6, Pleading, and Order 8. The heading, bar title, bar signature, bar verification part is all same as in a plaint. The content matter of the written statement is written in points that correspond to the points. Each point in written statement should accept or refute the allegations given in the same point. A written statement may also contain new points, objections to jurisdiction, peremptory pleas, etc. A written statement must also raise any set off or counterclaim, if any. Never forget to include certain key points defending your written statement. Some employees of these preliminary objections are shown below. Denial. The defendant denies those facts. The defendant doesn't admit those facts. Protest. The defendant denies that he made the contract alleged or any contact with the plaintiff. The defendant denies that he contracted with the plaintiff as alleged or at all. The defendant admits assets but not the plaintiff's claim. The defendant denies that the plaintiff sold to him the goods mentioned in the plaint or any of them. Limitation. The suit is barred by Article 1 of the second schedule to the Indian Limitation Act 19 87. The plaintiff's claim is barred by the decree in suit. The plaintiff is estopped from denying the truth. Order 13 of the Code of Civil Procedure 1908 deals with temporary injunctions and interlocutory orders. The burden of establishing the three ingredients for granting a temporary injunction is on the plaintiff. A temporary injunction cannot be granted to establish a new state of things differing from the state of things that existed on the date when proceedings were instituted. Except in exceptional circumstances, normally an ex parte injunction cannot be granted.